My guest today is Chris Hitchins. Chris is an employment lawyer and also the managing partner of the London office of the law firm Katten. Chris advises clients across many industry sectors, protecting their businesses, but also seeking to protect and enhance their workplace cultures and their reputations as employers. As a result, he has a broad practice covering lots of different areas from employee incentivization and retention strategies, benefits, restructurings and reorganizations, as well as advising clients on day-to-day issues. I'm delighted to be welcoming Chris to the podcast today. Chris, great to have you on talking about the risks of international employment and litigation.
Thank you. Great to be here.
Fantastic. So let's kick things off. Chris, I'd love to get some of your insight here. So what are some of the legal challenges that are typically facing borderless businesses or global businesses nowadays that you're seeing?
So from my perspective, I advise a lot about workplace culture. And while I'm an employment lawyer and I advise on the laws and how you comply with those laws, to me, the bigger picture is the culture and what the employer is trying to achieve. So if you are an international business, you probably have achieved a certain size and scale, and you want to ensure that your culture is the same across borders, and that then becomes a bit of a challenge from an HR perspective and an employment law perspective. So that I think is where I start, is what sort of culture do you have, and what sort of what do you want to be known for as an employer, and therefore let's look at the employment terms, how you manage your employees, the types of benefits, the messaging, the comms, etc. around that. So that's sort of my starting point. But then, of course, the laws are different, the customers are different, and if you try to adopt a one-size-fits-all strategy and you just have your template terms and they are, British or American or French or whatever, that may not aid the recruitment of candidates, because it may put them off because they think that you don't understand the local market, and it ultimately may lead to problems around retention as well. So you have to, while you want to maintain the same culture, you also have to take account of local customs and local laws and understand those and make adjustments accordingly.
Yeah, that makes total sense. One thing I wanted to get your take on actually is, you talked about kind of by definition, a global business or a borderless business will achieve a certain amount of scale. Now, something that I've certainly seen in the last few years is that historically, to be a global business, that was definitely true, and you have to be like quite a fairly sizable business. You have to be doing pretty well, at least in one market, to then start to expand into other markets. But also nowadays, you're seeing much businesses earlier on in their life cycle starting to go borderless as well, and starting to hire internationally. Are you seeing the same thing, or what's your take on that?
Yeah, so we do a lot of work with US employers, and typically the first instruction that we will get in London from a US employer is in the employment field. And it will be, we want to hire somebody in the UK, and these are the terms we want to use, and make it happen. So, and again, the first question is, well, what's your desired scale? Are you looking just to keep one person? Are you going to go to 2 or 3, or is this a dip in the toe? And if it all goes well, then you're going to scale up a lot larger, because that will influence what you put in place, because you don't want to change the T's and C's of the person that you've hired when you hire somebody else or when you hire 10 more people. So yes, we do see onesies and twosies, and questions then are around whether they're an employee or whether they're a contractor or consultant, and then the sort of the misclassification concerns that you have. And more these days, I would offer up the PEO solution, or the employer of record solution, as something which they may be interested in exploring. So we sort of generally do one, it's a simple instruction from a client's perspective. We just want to hire one person, make it happen. And then you waffle on for hours and you say, what entity are you going to have in that jurisdiction? Have you considered whether you have a permanent establishment and whether you have to pay tax there? Are they an employee? Are they a contractor? Are you providing any benefits? Are you going to scale up? Then you start to get a bit annoyed because you seem to be putting up a lot of barriers. But these are all things that I think are important from that scale perspective, because there's no point undoing what you set up, because the setup costs are funds that you don't get back again.
Yeah, the sunk cost fallacy. But it's really interesting about are you still seeing the UK-US dynamic being one of the most common requests you get? So US company trying to expand to UK, UK trying to expand to US.
We see more US to UK, but obviously it does go the other way. In the financial services sector, post Brexit, there was the drive to mainland Europe as well. So the proprietary trading sector moved a lot of their business to Amsterdam. Some of the other financial services institutions moved to Germany or moved to France or moved to Dublin. So it is quite common to advise on singular employment issues where the mothership is just dipping a toe in the market and generally wants to see, is there something worth doing? I don't want to go the whole hog. I don't want to set up an entity. I don't have to make filings. I don't want to pay tax. I just want to see, give it 12 months, see how it works out, and then we'll go from there. So generally, if it's a US to UK, generally we would try to handle all of the international element, because we feel that not that we understand the local law, but we understand how to interpret the local law for an audience in another market. So if it's a French company setting up in the UK or a UK company setting up in Germany, the people that we work with understand that the laws are different in different jurisdictions in the way that you would hope that an international business would also do. And then you can therefore translate what the client is trying to achieve based on what they would want to achieve in their own jurisdiction, and then set things up accordingly in the other jurisdiction so that they can achieve what they want to achieve, notwithstanding that the law and the custom is different. That's sort of the key to it.
Yeah, that makes a lot of sense. And certainly what you mentioned about Brexit, I can imagine that being a big trigger point for a lot of people setting up in mainland Europe, for sure. It's quite interesting because I think in the evolution of Omnipresent and what we do, we've certainly, a few years ago, a lot of the opportunities we were seeing were the onesie twosies, hiring the first person in this country, hiring the first person in that country, employees relocating from here to there, or we want to hire a support person to offer 24/7 support. But more recently, I think we're seeing more of these larger scale transactions. Maybe it's some kind of multinational company going through an asset purchase, or a multinational carve out, some of these larger type of opportunities, which then creates not just one jurisdiction to kind of explore, but a multitude, with each of them have a handful of employees in. Are you seeing similar things, and what kind of challenges?
Yes. Yeah. So I used to think that the Professional Employment Organization, PEO, was a US idea, but because I only sort of heard about it in the last sort of 5 years in the context of the onesies and twosies. And when I've spoken to my US colleagues about it, it doesn't seem to be necessarily a US idea. It's more it's more sort of international or generic. So we do see it in the transaction space, and we do see it where there's a larger workforce than just a handful. And I'm sort of speculating why that is. I suppose it's better known now. It's more socialized. It's a better worn path. It works. And from an administration perspective, it is a heck of a lot simpler. So if you're doing a transaction and you're acquiring businesses in 10 countries, and the company that's the purchaser has businesses in 8 of those jurisdictions, but has to take on the other 2, who's going to run those businesses? Because you may not be taking on the country head. You may not be taking on local HR, or it may be that the seller business manages things in a shared services way from a central location that you're not buying. So all of a sudden, the person who's running the deal is left scratching their head thinking, well, how am I going to offer a solution that delivers the business on day one, and how people are going to get paid? When's payday? How are we going to ensure that the benefits are the same if I have to enter into new benefit plans? And then the PEO solution, which maybe we'll talk about the distinction between PEO and EOR as well. But the PEO solution becomes extremely attractive in that situation where you can simply hand it over to somebody like yourselves and say, make this happen on day one. I just want to pay you a check, and it really needs to know how you've done it. I just want you to deliver X solution. So absolutely, we're seeing it more and more in the transactional field as a solution.
Yeah, absolutely. We've definitely had this where it's been, we're trying to complete the transaction within a few weeks. Please, can you do it within that time frame? Being one of the biggest kind of decision factors. But I guess back to kind of your specialty, you mentioned at the start about culture and what the employer is trying to achieve, and aligning cultures across different borders. I guess when you go through these multinational type transactions, aligning corporate cultures then throws up a load of different potential legal risks. And when you're thinking about integrating different workforces across different countries, right?
Yeah. So consultation with employees is important in certain jurisdictions, and in other jurisdictions less so. Consultation before deals go ahead, consultation before changes can be made. In some jurisdictions, they call them co-determination rights, which means that you have to reach agreement. You have to reach agreement with an employee representative body like the Works Council, or with the employers themselves. And there may be filings associated with changes that you want to make, and there will be penalties if you fail to do so. So, and it's not just the legal risk; it's the tone that it sets. If you are trying to, if you're doing it in good faith and you're saying we're going to harmonize terms and conditions, and generally everybody is going to be better off. We've got slightly longer holiday. We've got more generous family-friendly policies. We have a range of benefits that you can opt into. You've got to win the trust, and the workforce that's moving into that will hear the headline, but if as soon as you start to deviate from that, they may start to you may start to lose some trust. So the communications around what the terms and conditions are going to be and how you're going to run the business is very important. Reporting lines may change, and therefore the integration is key. Reporting lines may be across borders. People may not actually meet with their line managers face to face, and that can become problematic, particularly if they used to have somebody that they've reported into in the physical office. So all of these things need to be thought about and planned out. Just to try and sort of see it from the employee's point of view, or the individual employee's point of view. What are they expecting? What fears can you allay, and how can you make it feel either business as usual, if that's the effect that you're going for, or how can you make it feel like you're now working with us rather than working with your previous company, and this is how it's better, and this is how you can feel that that your career can take off as a result of it. So subtle ways and means around the culture and the integration.
Yeah, I really like that point about putting yourself in their shoes. I think that's the cornerstone of these kind of situations, right? Because any kind of transaction like that is going to have a degree of anxiety for the employees who are affected, and so thinking through everything from their perspective, I think is a really helpful point. But also, as you say, if you're going to be, even if it's just slightly increasing the offering that they get, increasing the benefits, it's a much easier story to tell than, oh, you've got less holiday now than you used to.
But then you do sort of a big mapping exercise, and you have sort of 20 different things that are changing, and you might intersperse the positive ones with the negative ones, and don't worry about this. This is not not such a big issue. But um, generally, if you have economies of scale in a jurisdiction, you might have a better purchasing power to buy better benefits, um, or reduce the cost and increase the scope. So there are those things to bear in mind.
Yeah, for sure. And do you ever see this kind of bleeding into things like ESG, environmental, social, and governance standards, and how they might be maybe affected with these different global workforces?
Y- Yes, and that tends to be, I suppose, there's different buckets. Tends to be much larger organizations where they have an ESG reporting obligation. So it might form part of their um, Modern Slavery Act statement from a UK perspective, that there are similar laws worldwide on that, where they have an obligation to put out on their website and in the public domain and in their financial statements exactly what they do from the environmental, social, and governance perspective. And obviously, I would be more focused on the social side from an employment perspective. So, workplace policies, benefits, mentor programs, um, uh, how you provide from a sort of hybrid working or flexible working perspective. Those sorts of things may feature quite highly in that. And again, local laws and customs may be different, or it may be different in the context of an acquired company. They may be used to having a different working pattern that you then now need to try to harmonize. So we see it in that context. I think also in maybe in the startup context, where they are looking for investor capital and they want to set the right tone about the sort of entity that they are. And therefore ESG principles, the thought processes might come to the fore as a way of establishing their identity and why people should invest in them or why customers should sign up. And again, certainly in the startup environment, you're looking at where individuals have become owners of the business, or they have an ownership stake, particularly the early stage management. They may have an equity stage, but they can their careers can grow and be fulfilled within the confines of the growth of that organization. So the employee's journey is intertwined with the startup company in that regard. So yeah, we see it in those contexts.
Yeah, absolutely. And a few things you touched on there. Certainly the climate tech space is one of the areas, especially in the startup community, that's still continuing to grow as far as we can see. And yeah, absolutely. As you mentioned, when you're joining those early stage companies, people are typically expecting, or employees are looking for like an equity stake, and that becomes even more complex when you're trying to manage the tax implications of that across half a dozen different.
I think it's quite interesting in the context of a PEO. So PEO, like Omnipresent, Professional Employment Organization, provides more than just the employer of record service. So the employer of record being a co-employment, if you like, relationship where, for the purposes of the tax authorities in that jurisdiction, the EOR is the employer rather than the parent company or local subsidiary. But the broader services that a PEO can offer, the benefits, providing the benefits and sourcing the benefits and administering the payroll, making the filings, etc. When you come to the equity piece, that becomes it's not something that PEO can do, save for some of the administration, because the equity is in a company that belongs to the parent group. It's not the equity of the PEO organization. And then you start to muddy the waters slightly, because what you're saying to the tax authorities in France or Germany or the UK is, well, the employer is the PEO organization, and we will deduct taxes and hand them over to the authorities. But there's this overarching arrangement between the employee and the parent company where they can benefit from the shares in that entity. So the tax obligation, if it relates to employment, is with the employer of record, but the money and where it matters, and the profit and the future success is of the business that they work for, albeit that they may not be employed by. So that you can see how that starts to muddy the waters, both from the tax perspective, but also from the limits of what the PEO can do versus how do you ensure that the employee feels part of one culture while we're offering this administrative solution on the ground.
Yeah, absolutely. And we've seen a huge different array of different types of employee share option schemes, all originate from different countries with different setups and different ways that they're managing it. So yeah, definitely that can definitely be a complicated area that's worth getting advice on. One of the other thing I wanted to touch on, so obviously Cat has a very broad range of clients across lots of different sectors, but I think also has a lot of experience in financial services and hospitality and leisure. And you mentioned a bit earlier about how financial services companies, that was the trigger from Brexit, was about then basically setting up regulated entities, I guess, in mainland Europe. But I'm curious to see if there's any other trends that you're seeing in those sectors, maybe around hospitality and leisure, and maybe perhaps having more flexible parts of the workforce, and how they tend to be perceived.
Yeah, well, I suppose it's not two ends of the spectrum, but it is chalk and cheese in terms of the way that people get paid and what have you. So obviously in the financial services sector, the compensation is its structure and amounts are vastly different from, let's say, the hotel or restaurant sector, and therefore the way that people get paid is a key driver to how they behave and what they're incentivized to do. So you have your base salary, and your base salary may be a modest amount or average amount, or it may be a fairly significant amount, but not a fairly significant proportion of what you're hoping to get paid. And then you would have a bonus. Your bonus may be deferred in order to incentivize you to stay or stop you from leaving, depending which way you look at it. You may have an equity piece. You may have carried interest or promotes or some sort of share in the success of the investment. So that if somebody's leaving or joining, they're very focused on, this is my last ever move, how much money can I make, and then I'm out. So, and of course that drives behaviors and drives fluidity in the market. So the employment laws around termination and around that managing people are the nuts and bolts is in the contract that you've signed and how much you're going to get paid. So that becomes the sort of the main driver. In the hospitality sector, you have a much more maybe fluid workforce where people may be working on an hourly rate. They may be working for multiple employers. They may be, for so long as these are allowable in the UK, have 0 hours contracts, so that you just have an umbrella contract and you pick and choose the amount of hours that you will provide. You have shift patterns. You may have a trunk system where you share in tips, but generally the level of pay is a lot less. Maybe the level of loyalty is a lot less because there's a lot more fluidity. So your concerns there are different from a financial services organization that is concerned to protect its client relationships and to protect its confidential information / trade secrets. So they don't want people to move on to a competitor and simply do what they're doing for their competitor, what they were doing for them the day before. So you would have maybe lengthier notice periods. You'd have the ability to put people on garden leave. You'd have a non-solicitation provision of clients and employees, and you would possibly also have a non-compete. So you don't tend to have that in the services sectors outside of financial services. You have them in C-suite and management contracts in other sectors, maybe not to the same length. And you have them in the M&A context as well, particularly if you're buying a business off management or an owner or a series of owners. Again, you don't want them to simply set up shop somewhere else now the next day. So it's there's a lot of differences. I think the EOR model works well in a lot of sectors. You may say all sectors. I think where we would see it less would be in the financial services sector, where somebody needs to be regulated, because if they're in the proprietary trading sector and they're trading their own money, then if the regulation issue is not required, then you do see EOR model. But if you need to be regulated, you have obligations to the regulator in that jurisdiction, and generally you may want to have as much control over that individual and their activities as possible. You also want to have control over the intellectual property that they create to ensure that that's watertight and it belongs to you. And you want to ensure that you have these post-termination restrictions, non-compete, non-solicits, which I know are possible through an EOR. You have to do a little bit of legal gymnastics to work out, to ensure that if you have a contract in place between the parent company and the individual, to ensure that the individual doesn't go and compete with the parent company, that parent company is not then deemed to be the employer and therefore have a tax obligation in the jurisdiction. The whole idea of the EOR is designed to mitigate. So it is possible, but it just it's to sort of work it out with the clients.
Yeah, absolutely. There's a few different kind of areas you're touching on there, which I think are really interesting. Definitely, it's really hard for an EOR to employ someone who is licensed or a regulated individual, or whether there's liability that then sits with the employer, because we're not a licensed. Well, in most countries, we're not a licensed. We don't offer financial services, right, as a legal entity. So that's something that's a challenge. Also, in some countries, it can be a challenge to do things like provide visas, because certain types of visas require employer-sponsored visas require kind of significant oversight and management of employees, for example, in the UK. So you can do things like get a technation visa. So there's workarounds if the employee can get access to the visa themselves, but to have an employer-sponsored visa in the UK is quite difficult. But in other places, like getting a blue card, an employer-sponsored visa in other places in Europe, it's much easier. That's my local train that goes past. We'll got that better. Yes.
Become 36. You're right to mention the visas. That when we see a US to UK and they have one individual and they want that individual to have a visa, and if they have a UK subsidiary that they set up, and then that entity sponsors the individual, or who's going to administer the license, you've only got one person in the UK, and that's the person who's on the visa. So that becomes a bit problematic to square away. In other jurisdictions, we have seen clients being the beneficiary of a PEO solution, where it may be if you're buying a group and you have employees who are employed in a jurisdiction, you may be buying the business rather than the shares. And that if you're buying the business, you're not buying the legal entity, but it may be the legal entity that's the sponsor of the employees in that jurisdiction. And you need to be certain that on day one, when you bought the business, that these people are still allowed to work where they're working, they don't get deported, or you don't get fined, or you're not banned from setting up there in the future. And we have been the beneficiaries of omnipresent in the particular instance I'm thinking about, having the ability to provide visas locally without the need for the company to set up its own entity.
Yeah, absolutely. And also understanding the process, I think, is a really important thing. Like, it's quite common practice to get visas in lots of different countries, but knowing that you might have to advertise a role for a certain amount of time and meet
Right.
different requirements. And then you factor in, well, actually, we can employ these people straight away, but actually there's a few others that might take a few more weeks because we have to jump through a few different loopholes. I think that's a really interesting thing, element to factor into certainly some of these transactions there. Okay, great. There was one other thing I wanted to mention. Oh yeah, so you talked about the financial services sector and the key things there. Oftentimes are looking to protect IP, non-competes, all of those kind of things, and I think that makes total sense. One of the things that we've seen, as you mentioned, like the more flexible end of the workforce that might be in the cheese section rather than the chalk section, to use your analogy. We've certainly seen some companies try and use that kind of employment model in certain sectors where it might not be kind of the most appropriate to try and for various reasons they might do that. But then that often gets picked up in due diligence processes during an acquisition or something like that. Have you come across those kind of instances yourself in your line of work?
Where a business is providing a workforce through a non-traditional method.
Exactly. Through like a contractor setup, but actually it's someone who is economically dependent on the client for their primary source of income.
Yeah,
And they're
yeah.
basically,
The classic is contractors engaged around the world. So you have a core business in Europe, and you've been dipping a toe in Asia and Africa for years, and you have a small remote workforce of 1, 2, or 3 people who you pay gross, and their job is to divert opportunities to you in Europe so that you can sign contracts with investors or sign contracts with clients or suppliers based in that jurisdiction where you don't have an entity. And yes, it will be typical to flag, here's the workforce of the employees, but here are the contractor arrangements, because when you're looking at the employment workforce, you're looking at potential liability, known liabilities and unknown liabilities, claims, when a bonus is paid, holiday accrual, recent redundancy rounds, grievances, etc., etc. If you're looking at contractors, you can have a whole host of contracts, very often in local language and in with English alongside. You take it in good faith that is an accurate translation, but of course the local language will prevail in case of dispute. So one of the termination provisions, it could be 5-year contracts. They could guarantee an amount. So you need to know how you can get out of them, but also you need to know, have they been set up correctly, and are we exposed to a tax liability through the operations of this person here? Should they have been classified as an employee, in which case we may be looking at fines and interest and social security contributions, that sort of thing. And also they may have employment claims that you haven't appreciated that they might have. But the fact that you may have been operating in a jurisdiction without the proper setup could cause longer term problems, such as a blacklisting of being allowed to operate from that country for X years, sort of thing. So they're fairly extreme, but you shouldn't just take it as read that just because it's been set up for some time that it's been done in a lawful way. And I think tax would be the biggest red flag, and the cost of having to take your medicine and pay the amounts in order to regularize those contracts. Get the right to talk.
Yeah, absolutely. That can be absolutely a minefield. I think in my experience, there's a couple of points in which these kind of risks get triggered. One might be an acquisition where the new company comes through during a due diligence process. They say, actually, these people who you've said are contractors, we think that they should be moved to full-time employment, and they try and resolve that risk before the transaction goes through. The other example that we've seen is somebody set up as a contractor, but then for some reason falls out with the company, and then you end up with a disgruntled employee in a Spanish court taking someone to to a tribunal. And that can also be quite challenging as well.
Yeah, then it's a question, and that's where sort of the EOR could potentially help, because it's a question of which entity are they suing? Because if they're employed or engaged by a local entity, then they've got an entity that they can sue, and that entity may or may not have assets. So they want to win their case, or they want to bring the case in order to get a settlement because it's just easier to make it go away. But ultimately, if the entity they're suing doesn't have a presence in that jurisdiction, they have to then, the Spanish employee or contractor slash reclassified as an employee in that example sues a UK company. The UK company doesn't otherwise have any business or assets in Spain. Then if they win that claim, they have to then try and enforce that claim in the UK courts. And while that's legally possible to do, it's time consuming and really expensive. So there are those considerations as well. So if you have employed someone through an employer of record, the hope is that the claim ought to be against the entity that employs you, which is the employer of record. And then in your contract terms with the employer of record, you'll cover off, well, what happens if the employer of record gets sued, and who pays for that, and how do we manage a settlement, and whose decision is it, and how much authority do you have and we have, et cetera, et cetera. But at least it's you've thought about those things up front, which I think is important.
Yeah, absolutely. I think it's really important to also have a good team of lawyers on your side for those instances. You never know when something might arise.
You never know.
Excellent. So last couple of questions for me, Chris. In what instances would you recommend an employer of record? You mentioned a few instances. Well,
all the time. Well, I think it's remiss of me to not offer it up as a solution. And I think in certain situations, as I say, come back to the beginning, it's a question of scale. It's a question of what are you trying to achieve to the client. And there are certain situations where the employer of record works very, very well. It's administratively very easy. It's quick. It works. It's a well-worn path, and you know what you're dealing with, and somebody else is managing it for you. So there's a lot of pros to that. So I would, let's say, almost always offer it up as a solution, but sort of have a pros and cons for this particular client in this particular situation. The question that comes up a lot when a client is entering a jurisdiction for the first time is the question of permanent establishment and tax. And while that's outside of my particular practice area, I see it a lot that a client thinks, well, if we engage another entity to employ this person for us, then we won't have a tax presence in that jurisdiction. But while that might be the ultimate outcome, you do need tax advice on that, because it depends entirely on what those people are doing and whether they're generating revenue for the mothership or another entity outside of that jurisdiction. And it will be very fact specific, and it's very costly to take a flyer on that. And no advisor will advise you to take a flyer because they're not allowed to do so. So you have to go into that with your eyes open and ask the question about permanent establishment and tax to ensure that if that's what we're trying to cover off, it does actually work from that perspective. So that's something that would form part of the advice and the decision as to whether EOR or a broader PEO solution is right for the client in this instance. But as I say, I almost always will offer it up these days.
Yeah, makes total sense. And definitely the point about just because you don't have an entity, it doesn't mean that you don't necessarily have a tax liability. I think that's a really crucial point. My final question is, what would be the Chris Hitchins top takeaways for a global business embarking on any kind of major M&A transaction right now?
Top takeaways from M&A from an employment perspective, culture, rolling that out internationally, integration, understanding local customs and norms, reporting lines, management of the employees. Who's going to do that? Is it the same people? Harmonization of terms and conditions and benefits. One that's particularly knotty, if you're buying a business rather than buying the shares or stock, is, do the post-termination restrictions that you have over the employees, let's say it's the management, do they bite and apply once you've combined two businesses? Because they signed up agreeing not to solicit the customers of the business that they signed up to. When you combine them in a larger business, does it still cover the larger business? And generally, it does not. So how are you going to manage that? And how are you going to incentivize people to work for the sort of enhanced business and the greater good? So things like that. And I suppose from a defensive perspective, when you're buying and you're looking at due diligence, you're looking at potential liabilities. While it sounds very negative at the outset of an acquisition, you're looking at the cost of termination and whether they want to do any reorganization, headcount reduction, change of roles. Do they want to do that up front? Is it better to get it out of the way, or do they want to do it at a time when everything is bedded down? Are they happy for natural attrition? What's it want to look like in 12 months' time? I think that's an important part of the consideration as well.
Yeah, so it sounds there's a lot there to take away, lots of considerations.
Yeah, lots to think about, but generally people won't be that focused on it, and somebody will have the task of managing the workforce integration, and particular challenges can happen when you're negotiating with the people that you then have to manage. So because they're getting paid out part of the deal, so you may or may not still be on speaking terms by the time you sign, and then you've got to all work together. And you've promised some large earnout that would make everybody rich in the future, but you've realized on day one that you can't stand each other, or that these people are the people that are going to deliver the value post acquisition. They've done a very good job up to closing, but with the scale that comes from the acquisition, they're not necessarily the people who are going to take it forward. So yeah, horses for courses, different challenges.
Yeah, no, huge amount to consider there. I think you made some really good points there. Chris, that brings us to the end of the conversation today. I've really enjoyed speaking to you today. I've got a lot.
Likewise, thank you.
Final question: what's the best way for people to get in touch if they want to speak to you?
I take so many WhatsApps these days, but I would discourage that. Bios on the website, Christopher Hitchins at Katten, email, and I will respond instantaneously. Generally, which I do at least to say when I can get back. So yes, through my website and through email, and my mobile number is on there too.
Fantastic. Thank you so much.
Pleasure. Well, thank you.